Assalamualaikum. My name is Badariah binti Khalid.
And my name is Anis binti Zulkafli.
And we are from TLB1. And today we will be presenting our land locate, which title is Lim Zeon and others, and Syarikat Gunung Sejahtera Sendirian Berhad. The decision for this case is from the Federal Court Putrajaya. Before we start, we will
divide our presentation into 4 parts. The first part is regarding the facts of the case. Second will be on the issues. Third will be on the ruling or principles of law. And fourth will be regarding the decisions of the judgment of the case.
Okay. First and foremost, I will start with the fact of the case. Okay. As you can see in this picture, this is the chronology or the graphic for the fact of the case. So in this case, the defendant or respondent, which is the housing developer, Syarikat Gunung Sejahtera Sendirian Berhad, had advertised itself as a housing developer of a housing project called Desa Sri Ampang Ipoh, and all 14 plaintiffs, the plaintiff or appellant in this case were the purchasers of the houses built by the defendant in the project. The plaintiff had entered into 2 agreements with the defendant. Under the first agreement, the plaintiff agreed to pay the cost of the development works carried out by the defendant. Under the second agreement, the defendant agreed to build the houses for the plaintiff within 2 years from the date of the agreements. Clause 13 of the second agreement provided for damages of RM50 per month to be paid by the defendant in the event of delay in handing over vacant possession of the completed house. There was late delivery of the houses in this case. So the issue that arises in this case is whether the agreements entered were in contravention of the Housing Developers Control and Licensing Act 1966 and the Housing Developers Control and Licensing Regulation 1989. And the second issue is whether damages for late delivery should be made subject to Clause 22, Clause 2 of Schedule G of the regulation, which provide for liquidated damages at the rate of 10% per annum of the purchase price. So that is the conclusion for the fact and also the issue from this case. Continue.
And we will continue with my part. Now I'll be explaining regarding the rules or the principles of law about this case. So the issue at hand is whether the agreements entered between the parties is contradict with the terms housing developer according to the Section 3 of Housing Development Act. Regarding the rules or the principles of law, Section 3 provides that an interpretation provision states that a housing developer means any company which engages in or carries on or undertakes or causes to be undertaken a housing development. Section 3 of the Act also provides that a licensed housing developer means any housing developer licensed under Section 5 to engage in or carry on or undertake a housing development and includes the holder of any power of attorney of such housing developer duly created under the Powers of Attorney Act 1949. However, in this particular case, the respondent in this case did not comply or did not fulfill the requirement of housing developer. Therefore, the court in this case, the federal court in this case had rejected the application of the appellant in this case. The second issue is whether the damages can be granted to the plaintiffs in this case at hand. However, in our present situation, the court was in the decision that the plaintiffs had agreed to pay the cost of the development works carried out by the defendant as per the first agreement entered between the parties. The plaintiffs in this case had also agreed to engage the defendant to construct houses on their respective building lots under the second agreement. However, it was a term of the second agreement that the period of completion of the houses shall be 2 years from the date of the execution of the agreement. It is not disputed that there was a delay in the completion of the houses, and therefore, in relation to this, Clause 13 of the second agreement stipulates that in the event of any delay to complete and hand over vacant possession, the defendant need only to pay damages of 50 ringgit per month calculated from the date of completion to the date of the actual delivery of the vacant possession. However, regarding the matter of the damages, the court was in the considering view that there is nothing to show that the defendant in this case was a licensed housing developer within the meaning of Section 3 of the Housing Development Act. Hence, the Court of Appeal is right in its finding that the court is not empowered to grant such a declaration as sought for the plaintiffs pertaining to the claim of damages. In conclusion, in the simpler words of these two principles of law, it is decided that the respondent in our present situation clearly is not a housing developer, falls within the ambit of Section 3 of Housing Development Act. Therefore, the court has no power or right to grant such declaration sought by the plaintiff, hence which resulting or consequence that the plaintiff cannot claim damages for the situation at hand.
That's all from us. Thank you.
Thank you.